Welcome back, discerning listeners, to AI Serendipity, where tradition meets innovation and we always ask the hard questions. I am Santiago Martín Caravaca, an Italian-Spanish dual qualified tech and IP lawyer, a technologist by curiosity, and your guide to the twists and turns of the Suno AI case. In today's episode, we are diving into Suno AI's answer, their formal response to the lawsuit filed by Universal, Sony, and Warner. We'll unpack the legal mechanics behind their denials, analyze their responses to the plaintiff's claims for relief, and explore the tactical brilliance or pitfalls of their strategy. Ready to dive in? Let's begin. So, what exactly is an answer? Simply put, it is Suno's formal response to the plaintiff's complaint, where they address each allegation head-on. Think of it as their chance to systematically dismantle the claims made against them, paragraph by paragraph. For context, Universal, Sony, and Warner's complaint outlines two primary claims for relief: allegations of copyright infringement for post-1972 recordings, starting at paragraph 83, allegations related to pre-19s recordings, starting at paragraph 92. Suno's answer follows this same structure, addressing each claim in sequence. Why is this important? It creates a side-by-side comparison of allegations and responses, making it easier for the court and us to see where the battle lines are drawn. Now let's talk about Suno's strategy. Litigation isn't just about what you say, it is about how you say it. Here's what Suno's answers reveals: strategic repetition. If you read through Suno's response, you will notice phrases like, "No response is required," "We lack sufficient knowledge to admit or deny," or "We deny the remaining allegations." It might seem formulaic, but this repetition is deliberate. First, it minimizes risk by avoiding admissions that could later be used against them. Second, it provides flexibility, allowing Suno to adapt as new evidence emerges during discovery. At first glance, it might seem robotic, but make no mistake, this is litigation 101. Minimizing risk. Suno's consistent phrasing leaves no room for ambiguity. By sticking to a script, they avoid the trap of admitting anything that could later be used against them. For instance, if they were to admit even a minor detail, the plaintiffs could use that admission to strengthen their narrative. Preserving flexibility. Why? When Suno states, "We lack sufficient knowledge to admit or deny," they are buying time. This procedural move allows them to reserve judgment until the discovery phase, where both sides exchange evidence. It is a way of saying, well, wait to see what proof you actually have. Shifting the burden of proof. This strategy forces the plaintiffs to substantiate every single claim with concrete evidence. By refusing to concede anything, Suno effectively challenges the plaintiffs to provide the facts that back their allegations. But now, let's zoom in one of the most essential parts of the complaint. Plaintiffs allege that Suno used their copyrighted recordings to train its generative AI model. This allegation strikes at the heart of the case because it directly ties SUNO'S technology to the alleged infringement. So, how does SUNO respond? With their standard playbook, we lack sufficient knowledge to admit or deny. Why not deny outright? Because denying outright could lock them into a position that might later be contradicted by evidence. Instead, this carefully worded response gives them room to maneuver. Now let's talk about legal conclusions and factual allegations. One phrase you will notice repeatedly in SUNO'S answer is the allegations contain legal conclusions to which no response is required. What does this mean? It is a subtle but significant distinction in litigation. A factual allegation might be SUNO used plaintiffs' copyrighted sound recordings to train its generative AI model. This is something that can be proven or disproven with evidence. A legal conclusion, on the other hand, would be this constitutes copyright infringement. That's an interpretation of the law, not a fact. By stating that no response is required to legal conclusions, SUNO avoids conceding any point that could later undermine their defense. It is a strategic way of saying, we disagree with your interpretation, but we are not going to argue it here. But why this strategy works? SUNO'S denials and reserved responses are more than just procedural. They are tactical. Here's why. Discovery focus. By claiming lack of knowledge, SUNO shifts the spotlight to the discovery phase, where the plaintiffs will need to provide, for instance, logs or metadata, showing that their recordings were used. And also, control of the narrative. SUNO'S approach subtly frames the plaintiff's claims as speculative. Without hard evidence, the plaintiff's allegations risk appearing more like conjecture than fact. Avoiding premature admissions. In a case as complex as this, where AI training processes are deeply technical, admitting or denying too early could backfire. SUNO'S strategy ensures they don't inadvertently concede anything that discovery might later refute. Now let's touch on an often overlooked aspect of SUNO'S answer, their response to the plaintiff's jury demand. The plaintiffs have requested a jury trial, but SUNO'S response is calculated. No response is required. To the extent a response is deemed required, SUNO denies that all of plaintiff's claims are jury eligible. What's going on here? SUNO is hinting that not all the claims, particularly those for injunctive relief, belong before a jury. This is a subtle way of pushing more decision-making power into the hands of the judge, who might be less swayed by emotional arguments and more focused on legal technicalities. Why does this matter? Because juries can be unpredictable, especially in cases involving creative industries and big tech. By questioning the scope of the jury demand, SUNO is not just playing procedural defense, they are strategically minimizing risk. Think about it. Keeping certain claims like injunctive relief in the hands of a judge could ensure a more measured legalistic evaluation rather than an emotionally driven jury decision. SUNO'S approach is a reminder that in litigation, every sentence matters, especially when the stakes involve intellectual property, artificial intelligence, and the future of creativity. So, what's the takeaway from SUNO'S answer? It is not about saying yes or no. It is about playing the long game. It is a masterclass in legal strategy. Every denial, every carefully worded response, and even their approach to the jury demand is designed to control the narrative, preserve flexibility, and shift the burden back to the plaintiffs. If this episode sparked your curiosity or left you with questions, don't just listen. Subscribe and stay with us here at AI Serendipity. Next time on AI Serendipity, we'll explore SUNO'S affirmative defenses, their offensive strategy to argue why, even if the plaintiff's claims could be true, they aren't legally liable. Then keep questioning, stay curious, and remember, innovation is inevitable, but how we embrace it defines who we are. See you next time.